IPR is a significant tool in today's era. The risk of an innovation getting infringed without the knowledge of an inventor stands very high. With the increase in the importance of IP, the crime in IP have also become the part and parcel of this digitalized era, sometimes even leading to the failure of businesses. Hence, strong IP laws give protection to not only such rights, but also to the economy of the respective nation. A very warm good morning to everyone present over here. Respected Dean Professor T.R. Subramaniam, our Director Professor Vijay Praneshwaran, all the faculty members of CMR University, School of Legal Studies, and my beloved friends. I, Shruti Chakravarti, a student of 9th semester, BA LLB, welcome you all on behalf of CMR University, School of Legal Studies, to this very engaging session based on the theme, One-Day National Seminar on Recent Trends in IPR. We are honored to have with us today our respective dignitaries, Dr. U.T. Vijay, Executive Secretary in KSCST, and Professor T. Ramakrishnan, Chair of IPR in NLSIU, Bangalore. To begin an auspicious note with an invocation ceremony, I would like to call Dharini, a student of 3rd semester BA LLB, to sing a song as a mark of respect and gratitude. Dharini.
सरस्वती नमोस्तुते शारदे विद्याप्रदे सरस्वती नमोस्तुते शारदे विद्याप्रदे सरस्वती नमोस्तुते शारदे विद्याप्रदे सरस्वती नमोस्तुते करकृतवीणा पुस्तक करकृतवीणा पुस्तक करकृतवीणा पुस्तक वरमणिमालालङ्कृत सरस्वती नमोस्तुते शारदे विद्याप्रदे सरस्वती नमोस्तुते नरहरिसुत विदिधारित नवमणियुगकं पुकणे नरहरिसुत विदिधारित नवमणियुगकं पुकणे सुरसेवित पदयुगणे सुरसेवित पदयुगणे सुदाकार समदवने सुदाकार समदवने सरस्वती नमोस्तुते शारदे विद्याप्रदे सरस्वती नमोस्तुते
Thank you, Dharini. That was a wonderful song. It was truly mesmerizing. Now, I would like to call over our respective dignitaries, along with our Dean Sir, for lighting the lamp. much, sir. Now, I would like to call our Dean Professor, Dr. T.R. Subramaniam, sir, for welcoming.
A very good morning to all of you present here. It's a great day because we are organizing the second seminar on intellectual property rights. So Karnataka State Council for Science and Technology has been doing a wonderful job in providing IPR education to almost all the students of Karnataka. Wherever possible, without wasting any time, they have been going there, educating them, and in this task they have considered CMR University as well as the School of Legal Studies as well. Now today's seminar is titled as Recent Trends in the Area of Intellectual Property Rights. Those who are very keen may be questioning us, what is this recent trends? Now just go back just behind 2 years during the course of the COVID crisis. The issues relating to medicine and the problems relating to intellectual property surfaced to us throughout the world. The states which have produced intellectual property rights initially produced and kept it for themselves and their people, and they didn't want to give it to anybody else. When the least developed countries as well as the developing countries approached them, they said, you can't do that. So it is here the state of India came to the forefront and was able to discover and has been in a position to help over 110 countries of the world in giving the medicine. And when these countries, the developed countries were approached, they said, both India and South Africa, approached them, permit us to produce, permit us to circulate. You produce and keep it yourself. What nonsense is this? They said, we will give permission, we will give the patent, but you have to produce only in your country, but you cannot circulate. See, this was the inhospitable situation that surfaced during the COVID period. Somehow, the period got over. It is at this juncture, the government of India decided that, remember, all the more education in IPR is given, it is still the more, with all rigor, has to be pursued, and we should be in a position to protect maybe all the IPRs in all the areas wherein protection can be achieved. And with this in view, remember, all the seminars should be in a position to take note of these factors into consideration. On behalf of the CMR University, the chairman, the chancellor, and the board of management, I deem it a great privilege to welcome Mr. U.T. Vijay, the executive director of the Karnataka State Council for Science and Technology. On behalf of the CMR School of Legal Studies, I request to present a bouquet of flowers to your colleague. We have with us an eminent scholar. He is holding the chair professorship at the National Law School of India, and he is none but Professor T. Ramakrishna. When we approached, remember, he immediately agreed, and he is with us today. And on behalf of the management and the School of Legal Studies, I deem it a great welcome to welcome you, sir. We have with us our Pro-Chancellor, Professor Dr. Subbareddy, and he was very keen, and he said he wants to come and learn and by sitting with everyone. On behalf of the university, I also welcome you, sir, and And we have with us Mr. Kodam Ram of the IRS, Government of India, and he is a resource person, not only in the area of GST and taxation, but even in the area of the protection of intellectual property rights. Today he will be speaking to you, and please listen to him whenever his chance comes, and he will be speaking for about 45 minutes on cyber crimes and its relevance to intellectual property rights. On behalf of the CMR group of institutions, I request you to present a We have our teachers as well, and we have our students, and we have students who have registered from other colleges as well. It is my sincere duty to welcome all of you, and good luck to you all through the day. Best wishes. Thank you.
Thank you, sir. Now, for inaugural address, we have with us today Dr. U.P. Major. Sir is presently serving as Executive Secretary in Karnataka State Council for Science and Technology and served in various capacities at KSCSTs since 1986. He has been associated with various projects and programs in KSCST as rainwater harvesting and an assessment for traditional water harvesting system in Karnataka, Suvarna Bhumi Yojana, application of 3D laser technology for 3D modeling of World Heritage Monument under IDH. His areas of interest are water-related technologies and has to his credit a number of national and international publications. He is a member of several expert technical committees of various academies, R&D organizations, and government departments. Sir, I welcome you on the stage for inaugural address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Good morning to all of you. Respected dignitaries on the dais, Vice Chancellor of this University, Dr. Subbareddy, Professor Ramakrishna, Dr. Subramania, Dr. Kodampuram, dignitaries of the dais, various faculty members, deans and HODs of this great university, CMR University, School of Legal Studies, students and faculty members and students from other institutions, my colleagues from KSCST, Karnataka State Council for Science and Technology. Friends, it gives me immense pleasure to be part of this inaugural session of one-day national seminar on recent trends in IPR. Very important emerging aspect of our life, intellectual property rights. We need to protect our intellectual property as it plays very important role in various stages of our state as well as country. And being a law students, you should not say that what is the connection between IPR and law students. No, you have very important role to play in IPR ecosystem. You can play a role of bridge connectivity between society and IP. As you all know that IP means whatever coming to our mind, inventions, innovations, we need to protect our inventions, innovations to take it to the development of our society. In this juncture, as a law students, you have important role to play, especially in the area of preparation of applications on design, trademarks, copyrights and so on as part of IPR ecosystem. Then whenever some legal complications arises, being a law fraternity, you have important role to play in order to protect the intellectual property of any individuals or firms. In this way, as a law student, we need to learn many more things on IPR. So, in this background, we should thank CMR University School of Legal Studies has been playing proactive role in taking IPR to the students, research scholars, even faculty members. Since inception of PIC in KCST, we have established around 69 IPR cells in Karnataka. Even CMR School of IPSL of CMR University, the School of Legal Studies, one among them. Among few IPR cells out of the 69 schools, 69 IPR cells, as far as law schools are concerned, just few among them, but it's been playing very proactive role in organizing lots and lots of activities pertaining to IPR. Lot of competitions have been conducted by this IP cell, lot of hackathon, many workshops and seminars like this have been conducted by this IP cell. In this way, I congratulate and thank the management, faculty, principal, especially Dean Dr. Subramania and his team for organizing this kind of very important activities on IPR. So let us congratulate him. In future days also can propose more and more activities like this for the benefit of our students in recent trends in IPR. Friends, if you know the importance of IPR, even Government of India, Ministry of Education has recognized the importance of IPR. It is making one of the criteria for having IPR cell in any universities. This year onwards, this academic year, Government of India has made having IPR cell is one of the criteria to get NIRF ranking. So, in this way, Government of India, state governments, many organizations are taking part in taking IPR to the next level. As you all know that IPR is comprising many types of IPR: patents, copyrights, trademarks, licenses, trade secrets, and geographical indicators. Even starting from filing of patents or copyrights or trademarks, it takes some time, between 6 months to sometimes even 2 years also. But not only filing of patent is not a important thing, again to take it to the next stage for the benefit of the society also plays very important role in IPR ecosystem. There are various stages of IPR ecosystem. In this juncture, we should know each and every stage of IPR ecosystem, and it will be dealt in detail technically by our colleagues, Dr. Kodantram, even Professor Ramakrishna also. They are all very key experts as far as IPR is concerned. Coming back to Global Innovation Index, still our country has to struggle a lot. Even last year, if you take an average of 65,000 to 80,000 patents are being filed by our country. Still we are in 42nd position. We need to climb up, we need to go up. Even compared to our neighbor country, China, it's spending around 3 lakh per annum. We have not touched even 1 lakh mark also. That is why we all have to think hard, struggle hard to take our country at least in top 10 positions. Even as far as research also concerned, again, our India, our great country, still is lagging behind to other countries also. We need to, as an academic institution, as a government institution, we need to spend more on research. We do some inventions, we should do some research for the benefit of our society. If you take even average also, we are not even spending 1% of our GDP, our country. Just an average of 0.7 of GDP we are spending on research. That's why research, patenting, innovations are playing very important role for the development of any country, development of any society. Then coming to our organization, Karnataka State Council for Science and Technology. Apart from IPR, you have been carrying out lot of activities using science, technology and innovation for the benefit of our society, and we have been technically supporting government departments of state government, both even sometimes government of India also, with support from R&D institutions and academic institutions like IISc, University of Science, ISRO, HAL, NAL, CMTA and so on. We have been carrying out activities in the major areas of water technology, rainwater harvesting. We offer end-to-end solution. We give technical solutions for having rainwater harvesting systems in your campus, both rooftop rainwater harvesting as well as surface water harvesting. We also give technical guidance for rejuvenation of traditional water harvesting systems which were built by our ancestors, our kings, our elders for the benefit of this society, which were used for domestic use to irrigation use, including religious purposes. All these traditional water harvesting systems which were built with the traditional knowledge by using locally available materials, almost 500, 600,000 years back. These structures are play very important role in the environment and ecosystem is concerned of our country. So we have taken up scientific assessment of these structures and we have given scientific measures for restoration of these structures. Around 14,000 structures across the state we have assessed scientifically and we have given scientific report to rejuvenate these structures to the government. Now this restoration of these structures are being taken up by the government under various schemes of both government of India and government of Karnataka. Again, under education sector, just 3 years since existence of our KSCST. KSCST was established in 1975. In the 77-78 itself, we took up a very novel and flagship program called Student Project Program in order to support, encourage the innovative ideas of our students, especially engineering and science students. So far, 46 series have been completed under this 46 series of student project program. 16,000 student projects have been supported by not only financial support, even technical support with support from IISc, ISRO, CMTI, NAL and other R&D organizations for the benefit of our student community. Out of these 16,000 odd student projects, more than 500 projects have been commercialized, have been utilized by the society. See the innovative ideas of our students. That is why, please try to learn, think, work hard for the benefit of our common people, our farmers, our society. That is why each and every student has important role to build the nation. Whether it is a law student, business master degree, business student, MBA student, even science student, or even engineering student also, you have a very important role to play for the benefit of our society. Again, we have also offered faculty project programs in order to take the student project program for the society. Now to scale up these projects, around 29 projects have been supported by KSST for the benefit of our faculty, which were carried out by their respective students in their institutions. Like this, we have been supporting lot of academic activities of any university, any institution in the state of Karnataka. Again, with support from government, both government of Karnataka and government of India, even through CSR funds also, we have been supporting remote areas of schools and colleges of remote areas of our state in order to establish e-learning schools, e-learning centers in their respective schools for the benefit of our rural students. Under energy, we also offer lots of R&D activities and even applications on solar energy, wind energy, biomass energy, biogas energy. Even in the years of 80s and 90s, we took solar water, we fitted on the van, almost covered entire state of Karnataka. Even we were through MNRE, we were offering 100% subsidy. Nobody was interested to take the install solar water heating systems. That much of hard work has been put in by KSH and other in support from other organizations. Now, even in rural area, if you construct house, you will have solar water on your rooftop. Like that, even rainwater harvesting also, solar rooftop lighting also should come up like that. We need to become self-reliant, whether it is a domestic or even any institution, any academic institution or university, we should become self-reliant. And also, you should not waste your kitchen waste as well as other waste from your bathrooms as well as other infrastructure facility of our institution also. We should try to find some energy out of that. We need to conserve. We should make our campus green campus. In this way, KCT has been supporting lot other various institutions in Karnataka to go for green campus. Even housing also with support from IAC, we also offer green technology, green building technology like that. And also we have two important center of excellence. One is on cyber security. That also plays very important role in this juncture. We have been facing a lot of problems on our e-transactions. That's why with support from Government of India and Government of Karnataka, we have center of excellence on cyber security also. Even if university comes forward, we can have one day workshop on cyber security also with experts from our cyber security cell from PACST for the benefit of our students. Because even last students have plays very important role in order to protect the cyber security. So, and also we have one more center of excellence on aerospace and defense. That's just one of the emerging area as far as economy of country is concerned. So like this, we'll be having other center of excellence also. Even one morning also we were discussing with Dr. Subramanian and Professor Ramakrishna sir, why don't we have center of excellence, a good institution or good council on IPR itself for benefit of our society, state and even country also. In this way we are thinking in this direction. That is why I urge, I request all the students of this university, please try to get benefit from this seminar, try to learn, try to interact with the resource persons, try to learn and think in future for the benefit of our society. So with this, I conclude my talk and I wish all the best and for the grand success of this today's one-day seminar. Thank you very much. Thank you.
Thank you, sir, for guiding us through importance and implications of IPR. Now, our next guest of this hour is Professor T. Ramakrishnan. Sir is the chair professor of IPR in NLSIU, Bangalore. He has completed his BSc in Life Sciences, LLB, and an LLM in International Law and Jurisprudence, MA in Political Science and Public Administration, post-graduation in Criminology and Administration of Criminal Justice, and PhD in Legal Protection of Well-Known Trademarks. Sir has also presented more than 70 papers, including both national and international to his credit, delivered hundreds of talks on IPR covering patent rights, copyrights, trademarks, and GIs in various platforms, associating with law firms, WIPO, KSCST, IIMS, DST, and many more. Sir, I would like to call you on the stage for keynote address.
the Pro-Chancellor of CMR University, Dr. Subbareddy, the Member Secretary of Karnataka State Council for Science and Technology, Dr. U.T. Pichai, the Dean of CMR SOLS, a legal scholar, a great orator, and a good friend of mine, Professor T.R. Subramanian, and my dear friend Kodan Ram, an expert in GST and many disciplines, including IPR, cyber law, and others. I recall having stood at this podium on 4th of May 2019 for inauguration of the IP cell of CMR School of Law. Then also I was delivering the keynote address. The only change that we find here is the then Vice Chancellor was sitting here and we have the Pro Vice Chancellor. Then Executive Secretary Hemant Kumar was sitting here, we have Pichai. Kodan Ram, of course, wherever IPR is there, he will be there. Wherever I am there, he will be there. He was sitting somewhere here along with Sarasija Padmanabh. 4 years have passed. I was waiting for the report from the IP cell of CMR School of Law, because I had made a request 4 years back that I would want to see the activities of CMR IP cell in the next few years. But COVID took away that opportunity, or rather gave them the opportunity, right, of not presenting the progress. Today I was expecting that. I do not know, right, without that I will not be able to comment at all or even suggest the way out. But I heard from Niranjan that amongst the IP cells in law school, CMR has been performing exceedingly well. I do not know what exactly he meant by exceedingly well. What yardstick he has to measure this progress in this particular institution also I do not know. Could be some comparative analysis he should have made, and then comparatively he would have said that this is doing better than other IP cells. If that is the case, congratulations. Congratulations for whatever you have done, and hope you will improve upon the present activities and go ahead in great strides. Last week I was in Jharkhand, went to Ranchi, and then was in a district called as Koderma. The Koderma district administration some 3-4 months back called me and said we have a product here, something very highly reputed. It's a sweet. We call it as Kalakand. And then we believe that this can get a legal protection. I said, fine, go ahead. If you believe that it's good, you can go ahead. No, sir. We want you to facilitate us to get the IP protection. The reason why they called me was 2019, when I inaugurated this. I also went and inaugurated our out-of-state campus unit of IPR. Having an IPR unit in Jharkhand FIPRA unit in Jharkhand with 3 research assistants there housed to improve the ecosystem of Jharkhand state. And we had done a study of all the GIs and filed few and got registration for the first GI of Jharkhand. And the Chief Minister and all the secretaries were impressed by that, and they said, of course, that project got over. There was only 1.5 year project and it got over. They said, we want you to handhold us. You know how difficult it is to prepare. I think that's what Vijay sir was telling you. How you have to prepare the application. How difficult it is for you to prepare an application for registration of GI. I started building a team, built a team there, and the team was supposed to collect information, not only the historical information about how that came to that particular place. They came from 2 persons who came out when partition happened, and they settled down somewhere in Alvar, and then they moved to Koderma, and in Koderma they started making this particular product, and then they started having Kesher, which got culturally acquainted with that particular territory. And what is that milk that they use? It is a buffalo milk that they use. Obviously, buffalo milk can be used only because it has a larger fat content. But what is the breed of buffalo? Murrah breed, they said, but even before Murrah breed was there, there was a local breed which was being used. And then what is the speciality of the milk that you get? It again depends upon the, number one, the soil condition. Why the soil condition? See how they get related. Why the soil condition? All this, we started exploring. I said, all this is you'll have to do. You can't just go before GI office and just say Kalakan is known everywhere and therefore you give GI to Kalakan. No, you'll have to establish that. Then soil test was done, not only in Koderma but in the neighboring district, to find out the difference in the chemical composition of the soil, which will have an impact on the vegetation of that particular region. And the vegetation of that particular region, right, is used as a fodder, and the fodder will have an impact on the milk. How you trace the relationship between the vegetation and the milk, and then take it to the process. So that process started, and 4 months on, still those comparative studies are going on. Scientific studies had to be done. And last week when I went, it was almost in the final stage, and then the drafting process has started. In your draft also, you should be able to tell them that this is unique for these reasons, and it is distinguished from other places. And of course, these exercises are going on. And the day when I was in Jharkhand, the minister from Meghalaya called me, the brother of Chief Minister of Meghalaya, Sangma, son of P.S. Sangma. And he said, we haven't registered even 1 GI in Meghalaya so far. I think that's the place where your assistance is required. The point that I'm trying to make here is this IP cell that we have in this particular law school should look around not in the state itself, but go beyond and look out for a situation where you can handhold people who have been creative, people who have been innovative, people who have unique products in the region, people who want to market their products in the market, ensuring their presence in the market without counterfeiters overriding them. That's it. IP cell should move forward. Is it sufficient if the IP cell merely file applications, draft applications and file applications? Patent applications can be filed. Would that be sufficient? And we have been telling that you should have a policy in which you should start off exploring in and around you. I was in CMR Institute of Technology, sir. After the inauguration here, we had a program in CMR Institute of Technology. There also, I think, we have a IT cell started. And there, I addressed them and said, the kind of research that goes on in every institution is of three types. First stage, faculty members have the ready prescribed textbooks in which the scientific literature is available. They read that, compare that with other literature, go and deliver it to the class. Finished, over. My job as a teacher is done. Because there is already material available, there is already established, that is the theory is already there, its application and done. The first mode of delivery of information in the scientific institution. But there is a second mode where each faculty member would have on hand a separate research project. He would be very much involved in the research center and the research project and would go ahead and then do independent research. And the research output that he gets in the course of independent research, he is going to take that into the classroom along with the information in the textbooks. So there is an addition of knowledge that he has generated, which he shares with the students, so that the knowledge base of students would be a little higher. But then, these are Pascal mode and other modes, but then there is a distinct set of researchers in the institution. That's where I spoke about in the CMR side. What is that? That is popularly called as the Edison model of research. In the Edison model of research, the researchers in an education institution would not be just involved in doing research independent project and then taking that particular information into the classroom, but they will be doing independent projects so that those outcome of those research will be capable of being applied in practice to the larger benefit of the community. So the applied research is the one where they are going to invest their time, energy and knowledge for generation of products that's going to help the community as such. You find the first stage there is nothing except the copyright protection that emerges. But in the second and third stage, there is something which goes beyond the copyright. And each individual researcher would be entitled for a patent provided at the appropriate time. The IP cell of that university recognizes the potential patent in that particular research output and goes for filing of a patent application. Whereas in the third one, at every stage he generates a product and that will be going directly for monetization or commercialization in the market, and the industry would welcome. Should an institution adopt Edison model of research? In every institution you should adopt Edison model of research. But then what is the role that law students will have? Perhaps your sister institutions. If you just take your IP cell into one of the departments of the engineering college, one of the department of pharmacy college, one of the department of medical college. I'm using medical college also. You'll be surprised that 2 years back we gave the National Innovation Award to a medical college coming from Kerala, which had the maximum number of patents filed and maximum number of patents commercially exploited. Chitra Institute of Medical Sciences was the one for which we gave the Innovation Award. When I said we gave, I was also a member of the jury and representing that we gave. Yes, medical college, and then you go there, do an IP audit. Do an IP audit and tell them, come on, you have potential IPs in your research. Iterate with them, discuss with them as to how that could be converted into a viable IP. Then handhold them, saying that this is a legal framework within which you will be able to protect them, support them. I know you will not be initially able to understand the technology itself, but they are there to explain you the technology, the progress in the technology, etc. And this is what is to be done by the IP. Right? Coming to the IP as such. What is the recent trend? Professor Subramaniam, he when he speaks elaborately on a particular subject, or at least touches the core. He said about COVID situation and the right to health. All of us have studied all international conventions relating to human rights, starting from UDHR. All those conventions have specifically identified the right to health. And the right to health in the general comment have also been held to include the right of access to the medicine. And that's on the one hand, and on the other hand, you have the pharmaceutical companies which are thriving by virtue of novel innovation that they have been doing in that particular field. They invest to innovate. And then market that particular thing and then recoup the investment that they have made, divert that for other research and then continue their research in that particular field. And generally we get an impression that pharmaceutical companies are the ones which are putting all the drugs in the market at an exorbitant price and then exploiting the society. But just think over for a minute that if there was no innovation happening in the pharma field, and if there was no new products coming into the market as a solution to any disease, what would have been the position of the world which is suffering from unknown diseases? COVID was one such unknown one. I often say whether innovations in pharma is required or not. There are various reasons that people keep giving. But the one reason which has touched my heart is most of us have thought, I'm sure most of you in this hall would have thought, if only this vaccine was available, before the onset of second wave of COVID in India, perhaps my so and so would have been here today with me. How many of us have thought about that? I think almost all of us have thought about it because most of us lost our dear ones during COVID second wave. Is that not a sufficient reason for innovation to happen in the pharma field and the medicine field? And if innovation happens, what are the triggering factors for this innovation? Out of many triggering factors, IP protection is also one very important triggering factor. And therefore, patent will have to be granted to incentivize that. And you will have to have a system within the patent itself which is also trying to prevent abuse of that particular monopoly by the patent. Both should be there. And from that perspective, if you look at, I would say, rather, patent system or entire IPR system is a clear balance between the monopoly individual rights and the community rights. Don't be carried away by the myth that IPR is monopoly and monopoly is killing the innovation. Not at all. You have an IP system which is a very well balanced system, right, which takes care of the extreme public interest in extreme cases through its own mechanism. I'll be referring to that. Is innovation or invention that happens here, is it by chance? Is it by design? Is it by plan? If you look at our pharma companies, it is by choice only. They prepare, they have an outline. They find out as to what is to be invented thereafter, which compound would be better, which compound would be less having adverse effects, etc. And then they start their research right away. Maybe there are neglected diseases and other diseases are there. But there are also instances where out of necessity innovations and inventions happen. Moving slightly away from patent law, I recall how Galileo was able to come out with the laws of pendulum. It was sheer accident. He was lost in the storm. He was searching for some place to hold. He goes into a church, sits in the church, takes it in the church, and then finds the lamp swinging from, because of the storm, swinging from one side to the other side. Something struck his mind. There is something phenomenal, some phenomenon is happening here. Do we expect him to run to his house, to his lab, and get a stopwatch to find out as to what is the time that it takes? What did he do? The pulse rate, right, which goes at a steady pace. He calculates, come to the center, so many pulses. Goes here, compare to the center, so many pulses. That is when he ultimately came out with that particular formula relating to how the pendulum works. And rest is history. Rest is history. And a girl, small girl in Hong Kong, during COVID period, she found that people go into the mall, come out, and there is, every time they get into the shop, they will have to hold the handle, push the handle and then get in. You do not know which one would be contaminated with COVID virus and how he is going to spread that particular COVID virus. She comes out very interesting with a handle containing an LED, and LED is mirrored with titanium oxide. The titanium oxide, and the moment this glows, the LED glows, the titanium oxide releases the energy which is going to kill 98.8% of the bacteria on that particular handle. So if I have put my hand on it, pushed it, and by the time it comes back, it would have killed all the germs on it, and the next person who holds the hand would not be infected at all. And how would that operate? Should you keep charging? Should you keep charging LED, etc.? He said no. Then that's not necessary. It would, the kinetic energy that goes here, the movement itself, that itself charges the LED. Simple, but that was the need of the hour. I am not telling you about remdesivir, which was in large quantity needed, remdesivir which was not available in US, and the US government said we were going to take away this particular remdesivir at this particular rate, and then Gilead comes out and says we are going to sell it at a lesser price. The threat of compulsory licensing itself forced them to sell it at a lesser price in US. But what US did, and what these major developed countries did at a particular point of time is something which it baffles us. They pre-purchased all the vaccines. 100 to 300 million doses of vaccine should be sold to US first by all these companies, and then whichever country you want to sell it later. Which means you blocked it, and we called that as the vaccine nationalism. Vaccine nationalism, we called it vaccine nationalism, and we found that when US was going for second dose of vaccine, there were more than 100 countries in Africa which had not even had a single dose of vaccine. That was the situation. So these are to be corrected. How are you going to correct this scenario? South Africa and India moved before the TRIPS and said, we would want the TRIPS waiver. IP waiver, we would like to want. Of course, it's subsided, and therefore the issues are not that important at present. That's what reminded me when he was referring to the situation. And when I said it is again the necessity, I remember one person by name Yuk. His name was Yuk, again from the Far East, who had gone to MIT in US. His brother meets with an accident. Multiple operations will have to be conducted on him. Hip joint gone, kidney gone, all these multiple operations will be done. You know, the multiple operation means incisions, and incisions mean loss of blood. bleeding happens, bleeding is happening, and initially let us stop the bleeding. And the existing mechanism of stopping bleeding was not that very effective. And this boy, not very old, maybe in his late 20s or early 30s, he found he was by profession, he was into the bioadhesive technology field. He was working on that particular field. And then he also had seen what are called as barnacles. You know, there are barnacles in the sea which are found attached to the rocks. They're attached to the rocks. Whether it is dry, whether it is wet, it keeps attached to the rock. How does it keep attached to the rock? It is by means of the sticky protein particle that it secretes. He was influenced by that. He said, if those barnacles can sustain in all these situations, why I cannot come out with an invention which is going to stop the bleeding instantaneously and prevent the bleeding at all. And therefore he came out with what's called the sticky microparticle and picked up the silicon oil, proportionately combined them, started experimenting on that. He found to his surprise that instantaneous stopping of bleeding happened there. And MIT is now looking for a global commercialization of that particular product. What I meant here is, again, it's the need of the hour. Apart from planned scientific investigation, there are also circumstances where you find problems aside and then you start building upon them. Therefore, it need not always be a new chemical entity that you invent. India has not so far invented even a single new chemical entity, if I remember, if I'm right. Right? And very few countries have. And based on that, API is generated, and based on API, we do the formulations, and formulations are administered to the patients. My point is, you need not always aim at a new chemical entity and a new product. Aim at solution to the problem that people are facing just around you. Your mobile is stolen, and you should have a mechanism for alarm. Just that. And you find a mechanism for alarm which would address this. An Intel employee, she was in a hurry to go to the office. She takes the car, parks the car, gets out of the car because there is a call from the senior, the meeting is on. She gets out, goes to the meeting, and after half an hour realizes that she had locked her child in the car itself. That was the scariest situation for her. She comes back, of course, but then she goes ahead with the research and develops an alarm process for alerting people who are having living, I would say living organisms. When I say it could be dog, it could be baby also in that, and that becomes a patentable invention for Intel, and she gets that. Doberman, again, all these are examples. I'll get into the technology transfer in a short while. She found that baby struggling hard to drink milk because half of it was spilled, half of it she used to drink. The mother was struggling hard. This lady found that and found several people. Then she said, why can't I start? You know, today you have Cup company. Paperman started a timing company, right? She started with a very small invention. Small invention was an upper chamber and a lower chamber in a bottle. An upper chamber which is porous, and the child sucks there. The lower chamber has the milk. Between the lower chamber and the upper chamber there is a valve, lid and a lever. And it is so structured that the moment pressure is applied, equal amount of milk goes into the upper chamber and the lid closes. The child would get only that child wants. And this was immediately commercially exploited. One unscrupulous manufacturer. He manufactured without taking license. Everyone took license. He manufactured without taking license. He was sued, and it goes before the court of law. Justice Reddy was deciding. And this respondent says, what is there in that invention? A liver and a lead. Liver and lead is known for ages. An upper chamber and a lower chamber. It is known for ages. Then Justice Reddy casually asked, it was so easy. Since you're in the market for 10 years, why you did not invent? Why did you copy it from them? The date on which the invention was made, the prior art did not indicate. I am getting into the prior art research that you are going to have. The prior art did not indicate nor gave any clue as to how to resolve that particular milk spillage problem in respect of the bottles. Which means there was a felt need by the community for a solution to have a spill-proof bottle. And Justice Lady says this is having an inventive step as on the date of invention. And you are not going to look into the condition of the technology as on the date on which infringement happens. But as on the date of filing of the application, was it novel, was it non-obvious, was it useful, etc. You are going to look into and then determine whether it is going to be patent eligible or not. This was such an invention at a particular point of time, and therefore relief was granted to the individual. But all this background is just to tell you that there are people not only in scientific organizations, not only in engineering college, not only in medical college, but around you who would also be individually inventing the products, processes. I think you should be able to capture that and then ensure that they are properly protected. And the point that I would like to make here is that advancement that we are referring to. Artificial intelligence is one thing that everyone speaks now. Artificial intelligence has become very common terminology. Artificial intelligence has become so common terminology that we keep relating to everything. AI for legal services, AI for health services, AI for record keeping, AI for everything, AI for everything. Yes, AI is guiding us also now. The moment you click on the response button, the keyboard opens, and you just type two letters, the entire sentence comes. If you want it, you can retain that. If you want to write new, you can also do that. My point here is, how does the IP paradigm gets modified in the light of intervention of AI? Whether AI will be recognized as an inventor of a product or a process, whether AI will be recognized as an author of a dramatic work, artistic work, literary work, or any other copyrightable work. Whether AI would become liable for copyright infringement or patent infringement when it adopts a new technology. These are the issues that have started coming. Can AI be an author? Can AI be an author? And your copyright law recognizes human creations as the creations which are going to be protected under the copyright law. Naruto versus Slater is a very big case which went before the California Supreme Court, and ultimately they said that an animal cannot be owner of a copyright in a selfie that it took, the monkey taking a selfie. Can it be an author? Can it be an owner? Court said no, copyright law does not allow for that. And the Copyright Office of US also clearly indicated, no, it cannot be having copyright over it. If that's the case, how do you look at the Indian position? In India, the moment you look at Copyright Act, it says, it defines as to who an author is. And in respect of computer generated works, it expressly says that the author is the one who causes the work to come into existence. Who is the one who is causing the work to come into existence? whether you use AI, whether you use any other technology, etc., you are giving the input and you get the output. And AI here merely becomes a tool, and that tool is used by you for getting the output. And you don't make AI the author here until you grant personhood to the AI. And that again is another area of debate into which I don't think I should be going into. Well, friends, the Dobbs case is one case I think as law students you can go through. Dobbs is an AI which invented two inventions for which Thaler who had created Dobbs, and by creating Dobbs, Thaler had made Dobbs invent two products. He files an application for patent and wanted to check the legal system in 17 jurisdictions. He names Dobbs as an inventor. He names Dobbs as an inventor and then files applications. Except South Africa, almost all the jurisdictions refuse the patent applications on the ground that Dobbs cannot be an inventor. US courts very clearly said that the terminology used is his or her, and his or her cannot be Dobbs. Dobbs cannot be his or her, and therefore it would not qualify. The whole jurisprudence of patent law is built on the human intervention. The jurisprudence of patent law is built on human intervention until that philosophy gets modified, changed to accommodate AI also. I don't think you'll be able to recognize AI as an inventor. And in the absence of AI as an inventor, I don't think you will be able to get its recognition as a owner also. You may start interpreting through jurisprudence saying that Ganga is identified as a person, idol is identified as a person, right? Company is identified as a person. Why not extend the same logic to AI also? And AI is still, I think, scientists would agree, AI is still a narrow AI that we have. Broad AI is efficient. You can think of personhood when the broad AI steps in. In the narrow AI, there is no scope for that. Again, calculation of human intervention, friends. I think law students should start thinking on this. What is the extent of human intervention that happens? When Anand Mohan Chakravarti went before the Supreme Court of US with his invention, which was a Pseudomonas bacterium. Pseudomonas bacterium had only one plasmid in it in the nature, and he generates a Pseudomonas with two or more plasmids in it and then claims a patent for that. When he went there, the Supreme Court had to interpret and say whether this organism is patent eligible or not. And the patent law said any manufacture, any composition of matter would be eligible for patent. And the court said any in US should be given the literal meaning. Any means anything under the sun. Any means anything under the sun. Identify whether it's a manufacturer, a composition of matter, and they said this is not a product of nature, this is what is created by human intervention. The word human intervention, one. Second, which is markedly distinctive from what is found in the nature. These were the two factors which tilted the entire balance in favor of Anand Mohan Chakravarti, and the patent was granted. Friends, from 1980, even you look at AI vision also, you will have to examine and find out as to what is the extent of human intervention that is there. You may say human intervention is more in my case, I should get protection for a variety. What is your intervention? I planted the seeds, I planted a seed, it grew, I harvested the seeds. While harvesting, I segregated the seeds, picked up the good seeds, and again planted, again harvested, picked up good seeds, and at the end, I was able to generate a new variety in itself. And the court would say, it is essentially biological processes. It grew on its own. It grew on its own. And essentially biological processes are not patent eligible either under TRIPS or under patent law of any country. So what is the human intervention here? In selection. Selection. But the process of development was biological processes. And therefore, this question comes up in the AI also as to what is the extent of human intervention that has happened if you want to change the patent jurisprudence. Accommodate AI invention. But then don't get confused here between two things. What I am trying to refer here is whether AI is the inventor, whether AI holds the right over the invention or not is the question. Our question is not whether AI invention should get patent or not. Whether AI invents or an individual invents through AI or himself, that invention is an invention. If it satisfies the requirement of the patentability, it would be eligible for patent. That is not our question. Invention satisfying the requirement of patentability would be eligible for patent. Who would be owner of that? Who would be inventor of that? Is the question that has come before us. Who invents is not so much more important for us. We have also said that even accidental invention would also be eligible for patent. Whereas Viagra itself is a standing example of patent, where a chemical compound used for a different purpose had a different function of setting right the other problem. And they said this has a second use property, and US had a patent for that. The point is a serious point where I say an accidental invention is not excluded from patentability. An accidental byproduct that you get in the course of investigation would not be excluded from patentability. When that is the case, AI's invention is always patent eligible if it satisfies those requirements. It will not be excluded. And there are instances, very many instances like the breast cancer screening has AI mechanism now. Stroke detection instrument has a AI interface. Patient monitoring has a constant AI interface. Drug delivery is having the AI mechanism. See, this small biocapsule can enter into your veins, go to the location, and then deliver the medicine at the appropriate cell that it wants. Scientists would acknowledge that. It can deliver that. So this drug delivery is being controlled and monitored by the AI. Is that invention an invention worth protecting? Answer is yes. It's to be protected. Which means AI interface is what I was referring to. And all copyright issues and design issues that we have been referring to are all in the field of creative industry. Friends, if this class, which is not interested in scientific innovations and patenting, because if you think in yourself that I am not a science student and therefore I will not be able to understand science. Science students are also like you. We did not know science before they entered into that. They did not know law, but we were able to get into that. And often science students who come and sit in our NGL class, they say, "Sir, it has been difficult for us to remember the sections." How do you remember sections, sir? I said, how do you remember formulas? No, sir, that is, we have trained in that. We also say we are also trained in that. So you said, training that matters. So should you also get trained in that? Sit with an engineer and then understand. Start reading patent law, patent decision judgments. Automatically you get to know what is that bit of science involved in that particular technology, which is patented technology. And you know, patent attorneys have become great inventors. They become great inventors because they keep looking at the novelty of all the inventions that they file for patent. And they absorb the technology so much that they start thinking beyond the application that they have filed. And they would be able to come out with new idea about that particular product. It's possible. It's been happening on so many occasions. creative industry I was referring to. Creative industry is very vast, starting from music up to cinema, the art, the culture, all these are included. And even festivals fall within the creative industry. You can't ignore a festival that happens. Go to, what is that place? Karaga. Just, I'm not exaggerating here even a bit. Go to the place where Karaga happens. Karaga is a festival. Karaga is a festival. You know what the kind of GDP it generates? In case of Durga Puja in West Bengal, official records show that more than 3% state GDP is generated during those 10 days in West Bengal. This Karaga festival generates so much. Mysore Dasara is a festival of lights. When I say festival, it's a creative industry. All creative industries are involved in that particular process. And are there any IP related issues that come up there? Can you just start probing into that and find out as to how you will be able to help the real authors and real owners of copyright, right, being compensated for the use of their copyrighted work in the entire program. IPRS would step in and then say, are you holding a function? Yes. Your institution is holding a function? Yes. Are you going to play all the songs in that particular function? Yes. Then you are expected to obtain a license from IPRS. And the money goes back to the creators there. Is it being enforced? Are you trying to enforce, protect them? I think you should start thinking. I have not gone into the development of other jurisprudence right now because they're all law students. I thought I should be getting into that as well. The international regime, friends, if you look at WIPO, WTO, UNESCO, FAO, UPOB, all these are administering IP treaties. WIPO itself is administering, I'm sure law students know, 25 international treaties, starting from Paris Convention, entered into in 1883, up to Marrakesh Treaty, entered into in 2013. India took the lead in Marrakesh Treaty, and India will be proud again because the WIPO IGC, WIPO Intergovernmental Committee on TK, Genetic Resource and Traditional Knowledge, Traditional Cultural Expressions, it has found that the discussion on IP, genetic resource and associated traditional knowledge, discussion on these three have reached a stage of maturity, and when it reaches a stage of maturity, that is when WIPO would convene the diplomatic conference. We have experts from External Affairs Ministry, but who knows that within the diplomatic conference the treaty would be adopted. That treaty is going to be adopted, and India is now advising the chairman of the WIPO IGC on the legal text. And that's going to be held in New Delhi. Imagine if that convention is adopted, like your Paris Convention, Bonn Convention, you'll have New Delhi Convention on genetic resource, IP and TK. That's happening in 2024, most probably in March by now, next year. It would have been adopted if it's going to be adopted. That's the development that's happening. What is that we are looking at there? You are looking at an interface between genetic resource and the CBD and the patent system. A patent application is filed before the patent office, and the inventor who has filed a patent application has taken the genetic resource from a particular country, X, Y, or Z country has taken. What is he expected to do when he takes genetic resource? In India, what is the position? I'm sure you know the Biological Diversity Act is there. It says you shall take the permission from the NBA. Then, can you file for a patent anywhere without the permission of NBA? No, again, you can't file application for patent without the permission of NBA. So the permission of NBA is required. Are you expected to disclose the source of genetic resource in the patent application? Yes. Permission? Yes. Now this treaty is going to determine as to what could be the sanction for non-disclosure of genetic resource in a patent application. Is that going to invalidate the patent, or is that going to impose obligation for benefit sharing on the patent applicant? On that issue there is some disagreement, and that disagreement is going to be patched. That's the development that's happening at the WIPO. WIPO negotiation is an interesting negotiation as far as copyright is concerned. Up to disabled persons, Marrakech Treaty is done, but still the discussion is going on various fields, on all limitations and exceptions. And the copyright is being debated even to this day. Library exception, right? Preservation, so on and so forth. There are education also. All these are being debated at WIPO. The point that I am trying to make here is, it's not enough if you study copyright law and the contours of copyright law within the framework of India. You also will have to look at the development that have happened in other jurisdictions to find out as to how it is going to have an impact. From constitutional perspective also you should be looking at IPR. How IPR has an interface with the Constitution. So that it happened once in US, before US Supreme Court, where the Nations, a newspaper, was sued by a publisher. Nation newspaper was sued by a publisher. What for? Copyright infringement. How did they violate the copyright? The serialization, before a book is published, there will be serialization rights given to the publisher, who can publish in excerpts about a particular book in the newspaper. Harper & Row was publishing a very important book of Gerald Ford, the then President of US of America. Memoirs of the President was the title given. And they wanted to publish that. When they wanted to publish that, it also had Nixon scandal, etc. in that particular book, which every American was interested in knowing. We also were interested in knowing Nixon scandal, etc. No, the serialization, entire article was prepared by Harper & Row. That was to be given to the Times newspaper, but somehow, stealthily, it moved into the hands of the Nation. How it moved, we do not know. And the Nation, the moment it got that particular write-up, it published in its newspaper. And after publishing, and when it was sued for copyright infringement, it raised two questions. It said, First Amendment of the US Constitution speaks about free speech, right? Freedom of speech and expression is guaranteed, and that includes freedom of press. And therefore the press, in the public interest, is expected to inform something which is important to the public. Gerald Ford's thoughts are definitely important for the public, and therefore our publication would be covered within the First Amendment of the Constitution. Whereas Harper & Row said, no, this is violation of the copyright, and copyright clause has been specifically incorporated into the very Constitution itself under Article 188. So both are constitutional provisions. And how do you examine, how do you look at this situation? And Supreme Court disposed it off by saying that copyright, I repeat, copyright is an engine of free expression. Copyright is an engine of free expression, and therefore copyright clause, right, would prevail over the First Amendment, because you are referring to the speech and freedom of speech and expression of the individual who has expressed, and there is no right for any other person to copy that. That's not included in the freedom of speech and expression. And the phrase copyright is an engine of free expression, therefore there is no overlap between the two. Is how it is. What's the time that we have? Yes, I was just looking at the watch. Then, with these friends, there are many developments that are happening. I think as IP cell proceeds, IP cell should always think of very important role of IP management. I am sure you will get into those roles also. You get into those roles very consciously, deliberately prepare a plan, enter into the IP management, guide the IP holders as to how they will have to effectively manage, enforce their IP in the society. And therefore, gone are the stages. Gone are the stages when IP programs are conducted to create awareness. Gone are those stages. Those were the stages in 1990s when we were trying to create awareness, sensitization. Now it is to induce in the audience the development that are happening at present and how to address those developments. How law will have to have an interface with all the development that are happening. And that is the stage at which we are. How technology should be transferred, how monetization should happen. That's the stage at which we are now. And that is what is to be done here afterwards. And whenever Department of Science and Technology says awareness programs, I stop them and say, no more awareness program. No more awareness program in the country. It is a time that we are going to commercialize the IPs that they have and enforce the IPs that they have at present and improve upon the existing legal system and the administration system. Administration system, all of us know. In 2016, with that I close. 2016, WIPO report said there are 2 countries which have the longest period of pendency of the patent application. 96 months Brazil, 84 months India. Right? 2016. And then that is when we had IP policy. That's when modernization of IP offices happened. From 70 IP officials, we have moved to 800 IP officials. Patent attorneys like and others, they said, we are not receiving first examination reports at all. Now they say, please stop sending FIRs. So many FIRs are flowing out of patent office. And the period within which you can get patent is reduced to less than 300 days. From 70, 84 months. That is the transformation that has happened in our country. And filing also from 12 to 18% of Indian applications, it has gone beyond 50% of Indian applications in the patent office. That's all because of those awareness programs that were done, sensitization programs that were done at the critical time, which has matured. And therefore, no awareness programs here afterwards, even by your IP sir. Start working on the developments. As law students, you have a great role to play in ensuring that you protect your IP first, look around, protect their IP, and look at the global scenario and try to write critical articles on how to ensure a fair balance between monopoly and public interest. With these few words, I congratulate the IP sir. I thank the Vice Pro-Chancellor Subhareddy sir, the Dean of Faculty of Law, Subramaniam, Mr. U.T. Vijay, who is now, he is in full swings now, right, of taking it forward, and my dear friend Kodan Ram and others. Karnataka Council for Science and Technology is the only one which has the maximum number of IP cells in the states. No other state has 70 IP cells. It is the only state which has 70 IP cells. And when the previous executive secretary Hemant Kumar was there, I was the expert group of the Department of Science and Technology. I asked a question, not as a citizen of Karnataka, but as an expert committee member. I just asked him, how many patents can you file in this year? He got up and said, around 500. Every state was saying 50, 60, 100, maximum 100. And he said 500. And the whole body was shocked. How can you do that? Then of course, I had to support him. Yes, more number of IP cells, more IP applications can be done. And that's how it should be done. That's it. Thank you, sir. All the best. Good luck.
Thank you so much, sir, for enlightening us with the contemporary developments in the field of IPR. Now, I would like to call our director, Professor Kaneshwaram sir, for a vote of thanks.
For those of you who do not know me, I am not Kanchanal Murthy. Indeed, a pleasant morning. Having inaugurated the one-day national seminar on recent trends in IPR. This is the inaugural session. We have had a wonderful keynote address by Professor Dr. Ramakrishna sir, IPR Chair, National Law School of India, University, Bangalore. Thank you very much, sir, for that enlightening keynote address. We are also thankful to Dr. U.T. Vijay, Executive Secretary, KSCST. We have had a very close tie-up and working together with regard to IP. Thank you very much, sir. We are very thankful to Professor Dr. Subba Reddy, Pro Vice Chancellor, CMR University, for his august presence. Thank you, sir. We are also thankful to Mr. M.G. Kodandram, IRS. He is also one of the panelists here today. He will be addressing you all on IPR and cyber law. Thank you very much, sir, for your presence. We are also thankful to our beloved Dean, Professor Dr. T.R. Subramania, who is instrumental in organizing this seminar. Thank you very much, sir. We are also grateful to the officials from KSCST for their presence. We are thankful to the participants from outside and also our students. We are thankful to the faculty, the organizers. Well begun, half done. You have 4 more sessions going on, but one most important thing about these seminars is starting in time and ending in time. But we do maintain time, so a big thank you to all. Thank you very much.